Good afternoon, everyone. My name is Zach Kaplan, and I'm the president of the Moot Court Board here at Duke Law. On behalf of the board and of the Duke Law community, it's my pleasure to welcome you all to the 2021 Hardt Cup Finals. Now, with no offense to the other two Moot Court tournaments that we host here at Duke, I have to be honest and admit that the Hardt Cup is my absolute favorite. It's not just because of the esteemed judges, the interesting cases, or the stellar participants, although they are esteemed, interesting, and stellar. Rather, the Hardt Cup is my favorite tournament because of the nature of the opportunity and the incredible growth that the participants show along the way. You see, just 9 days ago, 236 1L students got their first taste of appellate advocacy in the initial LARW rounds of the Hardt Cup. After arguing once on each side of an intricate statutory interpretation case and getting feedback from current Moot Court board members along the way, 82 students decided to continue to the opt-in rounds of the competition. These students then had about 30 hours between receiving a brand new case packet on Sunday morning and delivering their first arguments on that case on Monday night. And again, I want to stress that this part was all totally voluntary. After 2 intense preliminary rounds, again arguing on both sides of the case, the field was narrowed to 16 on Wednesday and then to 8 and 4 just last night. And today, of course, we are down to our final 2 competitors, Julianna Ricigliano and John Addy. Now, just 5 days after reading this case for the first time, Julianna and John will present their arguments before a panel of 3 very real and very incredible judges. And that is why I love the Hardt Cup. Before we begin, I'd like to thank several people whose efforts have made this tournament and this final round possible. First, I'd like to recognize our 4 wonderful Hardt Cup coordinators, Anna DeCenso, Aaron Flood, Daisy Gray, and Kevin Simpson, who have spent countless hours over the last several months organizing every aspect of this tournament. I'd also like to thank the LARW faculty for their great partnership in coordinating the LARW rounds, Sarah Emily and Lee Marquez from the clerkship office, and our faculty advisor, Professor Andrew Sear. Many thanks as well to all of the Moot Court board members who served as judges in the preliminary rounds, and to the professors and law school alumni who served as judges in the quarter and semifinal rounds last night, and to Dean Carrie Abrams for her support of our Moot Court competitions. Finally, and most importantly, thank you to all of the 1Ls who participated in the LARW and opt-in rounds of the tournament, and of course, to our 3 esteemed judges today. Chief Judge Anna Blackburne-Rigsby of the DC Court of Appeals, Judge James Wesley Hendrix of the U.S. District Court for the Northern District of Texas, and Judge Mary Scriven of the U.S. District Court for the Middle District of Florida, all of whom have given generously of their time in joining us for today's final round. Please find the full bios of today's judges as well as our competitors in our virtual event program, which will be sent through the chat shortly. Now, Hardt Cup coordinator Anna DeCenso will be summarizing today's case before we begin the arguments.
Thank you, Zach. Today's case will revolve around Jones versus Governor of Florida, and competitors will be arguing in front of the Supreme Court. The case revolves around the following set of facts. In 2018, the citizens of the state of Florida approved Amendment 4 to their state constitution, which would restore the voting rights of thousands of convicted felons. The amendment imposed only one condition on regaining the right to vote. Convicted felons would need to complete every term of their criminal sentences. The subsequent legislation enacted to implement the amendment defined the terms of the criminal sentence to include imprisonment, probation, and payment of any monetary penalties imposed by the sentencing court. Plaintiffs' petitioners are convicted felons challenging the Amendment 4 in Senate Bill 7066 requirement that they must pay their legal financial obligation in order to vote. Defendant respondents represent the state of Florida and are defending the legislation. The district court entered a preliminary injunction in favor of petitioners because it concluded they would likely succeed on the merits. A panel of the 11th Circuit affirmed the preliminary injunction, an opinion referred to as Jones 1, After a bench trial on the merits, the district court then found that Amendment 4 and Senate Bill 7066 violated the Equal Protection Clause as applied to felons who cannot afford to complete their sentences, applying heightened scrutiny, an opinion referred to as Jones 2. Respondents appealed and petitioned the 11th Circuit for initial hearing en banc and moved to stay most pertinent aspects of the permanent injunction granted by the district court after trial. The 11th Circuit en banc panel ruled in favor of respondents, holding that the Florida provisions re-enfranchising convicted felons pass constitutional muster under rational basis review. Today, Julianna Ricigliano will argue on behalf of the petitioner. John Addy will argue on behalf of the respondents. I now hand it over to Kevin Simpson, today's bailiff, to continue the proceedings.
The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon and welcome to the United States Supreme Court. We have one matter before the court this afternoon. At this time, are the parties ready to proceed with your arguments? We'll hear first from the petitioner. Excuse me, I'm sorry, before, didn't mean to interrupt you, Ms. Ricigliano. I wanted to welcome my fellow associate justices, Justice Scriven and Justice Hendrix, who are joining me on the panel for this argument today. Thank you.
Madam Chief Justice, and may it please the court. My name is Julianna Ricigliano, counsel for the petitioner, Calvin Leon Jones. With the court's permission, I'd like to reserve 2 minutes for a rebuttal.
All right, thank you. And you can proceed with your argument at this time. We do reserve the right to interject with questions, and if necessary, we can be a little bit flexible with your time in order to allow you to answer our questions. Thank you.
Of course, Your Honor. Your Honors, this is a case about voice. The voices of people trying to re-enter civil society and the voices of the Florida electorate. This court should reverse the decision of the lower court and hold that Amendment 4 in Senate Bill 7066 violate the Equal Protection Clause as applied to felons who cannot afford to complete their sentences for 2 main reasons. First, heightened scrutiny applies, and the law fails this standard. Second, even if the court does not apply heightened scrutiny, this law fails under rational basis review. To begin, heightened scrutiny applies for 2 main reasons, both of which on their own would be sufficient to warrant heightened scrutiny. First, heightened scrutiny is triggered in some cases when people are punished more severely on the basis of wealth. And this case is in line with the other cases this court has decided. Perhaps most importantly decided is the Harper case, which stands for the proposition that voter qualifications have no relation to wealth.
Before you drop too far into Harper, you say heightened scrutiny applies because anytime there's a law that punishes on the basis of wealth. Can you give me any example of a court applying heightened scrutiny when a law is challenged for either franchising or disenfranchising a class?
Your Honor, not any case that discriminates on the basis of wealth requires heightened scrutiny. It's a narrow set of cases, but the case at hand fits into that group. And in terms of—
My question was, can you give me an example of a case that did apply heightened scrutiny to a claim, equal protection violation or otherwise, based on disenfranchisement or franchisement of felons?
Your Honor, in terms of disenfranchisement of felons in our trial record, there is not a case on that topic in particular. But the Harper case does discuss enfranchisement, which is why it is the closest case to this example. So Harper goes for the proposition that it's a violation of the Equal Protection Clause whenever affluence is the voting standard. And as applied—
May I interrupt you? In the context of an equal protection claim, the court's first question is, to whom are the petitioners comparing themselves so that I can get my footing, are you comparing yourselves wealthy felons versus poor felons, all felons versus all non-felons, or poor felons versus all non-felons, or some other category?
Your Honor, this case is felons who can afford to pay their financial obligations versus those who cannot afford to pay their financial obligations in relation with their sentence.
Those felons who cannot.
Yes, those felons who cannot.
All right, continue.
Since Harper stands for this proposition, and one of the requirements in completing the sentence is paying back your financial obligation, that means that wealth becomes the electoral standard, which triggers heightened scrutiny.
Ms. Ricigliano, may I interject? If you could, having as a follow-up to Justice Scriven's question about who you're comparing, another element of the heightened scrutiny standard is whether or not something is invidiously discriminating against a particular group of people. And typically, heightened scrutiny we apply in cases of racial discrimination, discrimination based on national origin. How do we weigh wealth in there? Because typically when we talk about race, national origin, religion, we're talking about something that can't be changed. It's an inherent factor, and therefore discrimination based on that factor is invidious and inherently unjust. Could you address that element of the heightened scrutiny?
Sure, Your Honor. As you mentioned, race, national origin, and religion always trigger heightened scrutiny, but there is this narrow set of cases where wealth is considered invidious discrimination as well. This court in those cases typically has been able to figure out those who are genuinely unable to pay back those fines versus people who are either choosing not to pay back those fines or those who, for some other reason, aren't trying as much as they can. So for example, the court in Bearden said the state is not powerless in making these distinctions. And in the case in Bearden, if someone was willfully not paying back their fines, the state did have the ability to punish them. So in our case in Florida, the sentencing court would be able to figure out who was genuinely unable to pay back those fines due to no fault of their own, rather than those who were willfully ignoring the fines.
It doesn't.
Harper, sorry. Go ahead. I'm sorry, Justice Hendrix.
Oh, no, please, Chief, go ahead.
In Harper, we were dealing with the issue of a poll tax and unlawful, and we applied heightened scrutiny because it was deemed that that was an unjust and sort of invidious way of depriving someone essentially of the right to vote. In Griffin, can you tell us why that should apply here? Because we've declined to apply or extend the decision in Griffin previously to this type of case involving voter enfranchisement. I think that's a question that Justice Hendrix asked you earlier.
Your Honor, Griffin was used in the Harper decision. So Griffin has been extended past judicial proceedings into the mode of the political processes and voting. As for why Griffin should apply in this case in particular, the court realized in that case that the state was allowed to deprive people of appellate review, just like the state here was allowed to deprive felons of the right to vote. But then once that right is opened up to people, lines were not allowed to be drawn on the basis of poverty. So though Florida was originally allowed to deprive felons of the right to vote upon conviction, once the people of Florida decide to give that right back, lines cannot be drawn in ways that are inconsistent with the Equal Protection Clause.
Let me ask you this, assuming for a moment that a felon was convicted and his or her only obligation was to pay a fine, if we re-enfranchise that individual who has not completed any aspect of their penalty, then aren't we trampling on the state's rights, even under the heightened scrutiny, to impose some limitation on disenfranchised felons?
Your Honor, this court addressed that problem in Bearden and said that the state was not powerless. If someone is genuinely unable to pay, the state is not powerless in collecting nothing from that person. For example, this court said that you could extend the time frame for making the payment. You could lower the payment according to what the person could potentially pay back, or you could order that the person does something like community service. So if a person is genuinely unable to pay, that does not mean that the state is never going to be able to make sure they meet the demands of justice. It just means that in the meantime, they should not be able to deprive them of the right to vote. Sorry.
I'm sorry, may I turn your attention briefly? We can come back to the heightened scrutiny if you have not completed your points on this, but if we disagree that heightened scrutiny applies in this context, can you tell us under the rational basis test, is your argument that the state's interests here are not legitimate, or that the law as it's currently crafted, SB 7066, isn't rationally related to the state's interest?
Your Honor, the state's interests are questionable, but for the sake of argument, assuming the state's interests are legitimate, the ways they go about completing
what do you say the state's interest is, and why do you say it's questionable first, I guess?
The majority opinion on the 11th Circuit reframed the state's interest as both disenfranchisement and reenfranchisement. Amendment 4 in Senate Bill 7066 only reenfranchise people on a conditional basis. There's no disenfranchisement mentioned. And the goal of reenfranchisement merely restates what the law does rather than what the interests supported by the bill are. Assuming the state's interests are legitimate, though, they're carried out in arbitrary and irrational ways. So as already stated with Harper opinion, if the goal is reenfranchising only people who are fully rehabilitated, the idea that a poor person cannot be rehabilitated is irrational. If someone is genuinely unable to pay back a fine, that does not mean that they're not worthy to re-enter civil society. If the goal is meeting the demands of justice, then it warrants questioning why part of those fines that felons have to pay back may include paying for a public defender, which they had because they couldn't afford counsel in the first place. And now the state is trying to deprive those very people from having a voice in the system. Additionally,
is the goal restitution, making the victim whole, or is the goal rehabilitation? Is one of those goals more rational and more supportable in your view under the rational basis test?
Your Honor, if both of those are Florida's interests, neither are carried out in rational ways. So if restitution is the main goal, then someone who's genuinely unable to pay back that fine still wouldn't be able to pay their restitution, whether or not we give them the right to vote. And many other aspects of Florida's system.
The question is why is it irrational for a state to require, in this example about restitution, why is it irrational, and as we would be required to find, to go with this argument, that it is a bare desire to harm a politically unpopular group? For a state to say, before you have completely paid your debt, you need to make whole those who you have harmed. We can create a payment plan if you have difficulty doing that, but you've defrauded someone, you owe them money, and sometimes it might be $1,000, sometimes it might be $10 million. Why is that irrational when we're talking about victims of financial fraud and crime?
Your Honor, it's irrational because if people are genuinely unable to pay back the fine, then no matter how much the victim might be owed, that indigent person cannot repay the price. And many other aspects of Florida's system.
That might be so. There certainly are criminal defendants who are unable to pay their restitution or unwilling to pay their restitution. You cabin that as a violation of equal protection because it is discriminating based on lack of wealth. Why isn't it the state saying part of your sentence, part of your debt to society, regardless of your wealth, again, whether it's 1,000 or 10 million, is to make this victim whole. And until that happens, your sentence is not done. Tell me why that is an irrational goal of the state to protect victims of crime.
Your Honor, because as mentioned before, many aspects of the person's fine does not go to the victim. And again, just because we give felons the right to vote does not mean that they would be off the hook for paying back these fines. The victims, again, through constitutional right, are owed this money, but the felons would still be responsible for paying that back, regardless of when we grant the right to vote back or not. So I see my time has expired. May I finish answering the question and briefly conclude?
Yes, please. Thank you.
Victims would still be owed their restitution. It just doesn't have to be through every election while a person is indigent. For the foregoing reasons, this court should reverse the decision of the lower court. Thank you.
Thank you.
All right. Thank you, Ms. Ricigliano. Is the respondent ready to proceed at this time?
Yes, Your Honor, I am. Thank you, Madam Chief Justice. Your Honors, and may it please the court. My name is John Addy, counsel for the respondent, the Governor of Florida. This case is about Florida welcoming back those who have wiped their slate clean. The 11th Circuit held Florida Senate Bill 7066 constitutional as a means of restoring returning citizens' right to vote. We now ask this court.
Mr. Addy, can I interject? Initially, the amendment did not specify the payment of fines and financial obligations. It was the state legislature with legislation that followed the constitutional amendment, which was passed by the electorate, that added or further expanded, defined, explained, I don't know which word you would use, that this financial obligation had to also be met with respect to fines, which in many instances would mean that people incarcerated for decades with no financial income would have the burden of paying substantial financial obligations. What do you make of what some might argue, the expansion of what the electorate passed with the constitutional amendment by adding or making clear that the fine payment, as opposed to fulfillment of jail time, probation, or parole, should also be a requirement?
Yes, Your Honor. The face of the amendment makes clear that Florida voters had in mind that not every felon would be automatically reenfranchised, because the Florida Constitution and the amendment include things like denying automatic reenfranchisement for felony sex offenders and murderers. Rather, the distinction that's been made is felons who have completed their entire terms of their sentence, which sometimes includes monetary obligations and many times do not. And the 11th Circuit voted to make the 11th Circuit held this constitutional, and we ask this court now to affirm that for two main reasons. First, the 11th Circuit properly applied a rational basis standard of review instead of heightened scrutiny when evaluating this law. And second, this law clears rational basis analysis. In 2018, Florida took a huge step in both voter and criminal justice reform by passing this law. This law restores enfranchisement rights to felons who have satisfied the demands of justice. Now, it should be emphasized, when equal protection claims like this one are made, the default rule is that rational basis review applies. Heightened scrutiny is only invoked in narrow situations, not in cases like this, which do not discriminate on suspect classifications.
Mr. Addy.
Let me ask you if you consider it to be rationally related to a legitimate state interest to preclude a defendant who was indigent when incarcerated, who served a sentence of 8 years in prison, who's left with a $500 fine principally tied to the cost of his defense, to be denied the right to vote, while a multi-million-dollar Ponzi scheme perpetrator who had a $2 million fine but had his money stored away somewhere and is able to pay his fine to be allowed to vote? What is the rational relationship between those two decisions?
Yes, Your Honor. This court held in Richardson that states have a penological interest in disenfranchising felons who have committed an injustice which requires remedying. Now, it follows that if a state decides that those who commit serious crimes are presumptively unfit to vote, then those who paid their entire debts to society by completing all terms of their punishment are the best candidates to regain that right to vote.
Well, I understand the premise, but what is the rational relationship of that premise to any state interest in the context of the hypothetical?
I'm sorry, Your Honor, I'm not exactly sure I follow the question.
What is rational about telling a person who's committed a multi-million-dollar fraud, who has stolen money, now is able to repay it to get back on the voter rolls, to allow that person to vote, while telling a person who spent 8 years in prison to meet his debt to society, but doesn't have $500 or a penny to rub between two fingers, tell him he can't vote? What is the rational interest of the state in that?
Certainly, Your Honor. Well, in each particular case, the sentencing court made a decision to impose a particular punishment of all terms of their sentence that reflects the culpability of the felon before them. And that punishment is the repayment necessary to remedy the injustice that the felon caused when committed the crime. And if the injustice of the crime itself was the disqualifying factor that led to the disenfranchisement in the first place, the remedying of that injustice by completing all terms of the sentence, no matter what terms those actually are, remedies the injustice and removes the disqualifying factor. And those people are, it would be rationally related to consider that those people who have satisfied the demands of justice are the ones that ought to be first to regain the right to vote.
Well, in Bearden, Mr. Addy, we reasoned that the scheme was in fact discriminatory because it deprived someone essentially based on poverty from a desired benefit. Here, I guess, if looking at the two hypotheticals that Justice Scriven posed to you, it seems from the hypotheticals, at least, that the two felons, there's a discriminatory application of this statute with respect to the two felons based on wealth. Both are felons, both are convicted, but one can afford to pay the fine imposed and the other can't. That seems like, if we apply the Bearden analysis, that heightened scrutiny would also be applicable here.
Your Honor, I would make a couple of points. First, Bearden deals with imprisonment for failure to pay fines and sentences, but it is not applicable to this case because Bearden has never been extended past physical imprisonment, and requests to extend it have been explicitly rejected in the past by this court in cases like Kadermas. But to
why should it be rejected here if we apply the reasoning of some of the prior cases that you cite?
Your Honor, you're asking why heightened scrutiny should not be applied here?
Yes. Why shouldn't we extend it here, assuming we have the ability as the Supreme Court to do so? Why? What would be your rationale for why we shouldn't?
Yes, Your Honor. The petitioners ask you to extend doctrines from unrelated case law and inapplicable case law in order to justify heightened scrutiny in this area. The default rule is that wealth is not a suspect classification. And in order to try and invoke it as a suspect classification to warrant heightened scrutiny, petitioners pointed to a couple of cases, none of which apply to the case at bar here. Now, first, Griffin, that was used to bring in the idea that wealth is deserving of heightened scrutiny. But it should be noted that Griffin and its progeny are about access to judicial proceedings, such as counsel, transcripts, and appeals, which do not bear any relation to the right to vote that is at issue here and do not claim to do so. And each have been specifically cabined on the grounds of the criminal proceeding facts that were in front of them.
That's just not so. I mean, Bearden specifically relied on Griffin to extend its scope. Am I wrong about that?
Your Honor, you're absolutely correct. Bearden itself was a jump from Griffin.
So you say that these cases have been cabined, and I understand why you would like to do that. But at the same time, Bearden relies on Griffin. Harper relies on Griffin to invalidate Virginia's poll tax. You seem to consistently be running into the teeth of Supreme Court precedent that consistently apply heightened scrutiny anytime the state tries to deprive a benefit from a citizen based on poverty. I understand this case factually is different, but there seems to be a theme in our case law that heightened scrutiny applies under circumstances like this. Why isn't this just the next step?
Well, Your Honor, Bearden itself was as you absolutely noted, Bearden itself was a jump from Griffin, but was explicitly cabined at imprisonment. And further, Williams, one of the other key cases upon which Bearden relies, notes this, where this court notes that it has not cabined the state's ability to impose alternative sanctions other than physical imprisonment for defendants who cannot satisfy the monetary terms of their sentences. And certainly disenfranchisement would be classified as an alternative sanction that this court has signed off on imposing. And to Harper, petitioner attempts to bridge the gap between Griffin and this case by pointing to Harper as an extension of Griffin to the ballot box. But it should be noted that in Harper, Griffin is merely a C-site to demonstrate a general example and cannot be said to extend Griffin in any meaningful way.
Okay,
but
well,
further,
let me ask it this way then. Could a state re-enfranchise white felons but not black felons?
not at all, Your Honor. That would invoke
Could a
directly a
state
suspect.
re-enfranchise men felons, but not female felons?
No, Your Honor. Those
All right. Hold on. Could a state pass a law? What if Florida had passed this law to limit only those felons who have paid their monetary fees are allowed to vote again, right? If other portions of your sentence still exist, we don't really care. This is what's important to us. You must pay your restitution or your fees or your financial obligations. Would that survive either heightened or rational basis scrutiny? Is your argument different under that circumstance or the same?
Well, Your Honor, I believe your hypothetical is specifically about re-enfranchising those who have completed all of their terms except for the monetary terms?
Nope. The only term you must, to be able to go vote again, the only thing we require in Florida is that you pay your fines or your restitution or financial obligations. We don't care about everything else. That's how you get in. Would that be okay?
Your Honor, I'm not sure. I've not done the analysis on whether that specific term would satisfy scrutiny.
Mr. Addy, how do you respond to Ms. Ricigliano's argument that if the state really has a rational basis in ensuring fines are paid, it can satisfy that rational basis by waiting, allowing people to vote now, but imposing longer terms to pay their fines, paying them later, paying them over a course of time. They're not giving up their interest in the fines, and the person still can have the right to vote in the meantime.
Yes, Your Honor. Well, we'd note that under rational basis review, the law need only be rationally related to any conceivable governmental interest. And that under rational basis review, Florida does not have to draw a perfect line or even a better line. The line need only be rational. Now, as the 11th Circuit noted below, the law must stand unless petitioners can negative every conceivable basis which might support it. So, for example, Florida has a conceivable interest in re-enfranchising felons and bringing them back into the represented political community after justice has been done, after the injustice of the crime has been fully recouped in the form of the entire sentence that was imposed upon the defendant.
So your argument falls under the weight of your theme, which is welcome back felons to Florida to vote. That is not the theme of Florida. It is, we don't want anyone to vote unless every I is dotted and every T is crossed, even if you're otherwise doing everything rationally and legitimately necessary to be a productive citizen.
Well, Your Honor, if the state, under the Richardson analysis, when the state has determined that the crime that's been committed is a disqualifying factor from the franchise, that once that crime has been fully negated by the serving of the entire sentence that's been imposed, that disqualifying factor is simply no longer in play.
And then those people who pays the fine.
I'm sorry, Your Honor, I didn't catch the question.
Does it matter who pays the fine? Could we just set up a fine fund and anybody who needs the money can just go get the money out of the fine fund and it's publicly funded by crowdfunding? Would that be in any way connected to Florida's asserted rational basis?
Well, yes, Your Honor, it would matter in this instance because the sentence itself is a reflection of the culpability of the offender who committed the crime.
Well, what I thought you said that the fine is important to make the victim whole. And if the fine is paid, irrespective of who pays it, particularly where the convicted felon is unable to pay, and that's the only thing standing between that convicted felon and the right to vote, why should it matter who pays the fine? And doesn't this get us right back to the question of how is the payment of the fine rationally related to being a member of the electorate? Somebody who served 50 years in prison, no income during that time, and has a fine of any amount that they're unable to pay. Why couldn't their family pay it for them? Why couldn't crowdsourcing pay it for them? If that is so critically connected to, I guess, satisfaction of their debt to society.
Certainly, Your Honor, the restitution of the victims and making them whole is an important interest. And there are many ways that that could be accomplished. But again, under rational basis review, due deference is owed to the Florida legislature and the democratic deliberations that took place. Florida did not have to draw a perfect line, only a rational one. And ensuring that any conceivable government interest, this law has a rational relationship to it, this bill would satisfy.
Is Florida's interest, again, rehabilitation of the defendant so that they are deserving of re-entering and resuming all of their rights as citizens, or is it restitution?
Your Honor, I see my time is up. If I may briefly respond and then conclude.
Yes, please. Thank you.
Certainly, Your Honor, there are many potential interests of the state at play here, including restitution, including some rehabilitation, and including serving the demands of justice for those who have committed a crime. But each of those potential interests have rational ways to connect the law at issue here and ensuring that that former felons have served the entire sentence that they've been handed down. So for the foregoing reasons, Your Honors, the 11th Circuit was correct to hold this law constitutional, and we ask this court accordingly affirm its decision. Thank you, Your Honors.
Thank you.
Thank you. Ms. Ricigliano, I believe you reserved a few minutes for a rebuttal.
Yes, Your Honor. Thank you. I have 2 points to make. First, the interests of Florida remain unclear. Again, is it rehabilitation? Is it meeting the demands of justice? Let's assume it's all of them. One thing that is undisputed that the district court found was that Florida often cannot tell felons how much they owe. If the goal is felons completing their sentences and the state doesn't even know what amount it takes to complete that, then how are the goal and the interest related? Additionally, Florida uses something called the every dollar method, which means that many people could technically be re-enfranchised without paying the full amount of their financial obligations back, so long as it is more than the amounts initially ordered. So again, if one of the interests is meeting the demands of justice, then why does Florida itself have a system where people who did not pay back the full price could be re-enfranchised? Additionally, my opposing counsel spoke about how other cases do not extend here, and I want to briefly reiterate how that is not true. As my opposing counsel discussed, Harper did cite Griffin. So Griffin is not closed off to judicial proceedings. It has been extended into the arena of the political processes, and Harper is not the only case to do so. This court in MLB v. SLJ said that heightened scrutiny would apply, and I quote, in cases involving the basic right to participate in political processes as voters and candidates. This case law has been extended to voting already. This is the next logical step in making sure that people are assured a voice in the political process, regardless of whether they are wealthy or not. Thank you, Your Honors.
I have one final question, if there's a few more seconds. And it's almost existential. I mean, how does distinguishing between felons who have completed their sentencing, including the fines, and those who haven't, turn on a suspect class? I mean, isn't it just the case, as the record would bear out, that There are wealthy prisoners who haven't paid and poor prisoners who have. So is this really targeted at wealth or just completion of sentence?
Your Honor, I see my time has expired. May I briefly answer?
Yes.
The district court found that it was undisputed that the overwhelming majority of felons who would otherwise be eligible to vote but have not completed their financial obligations are genuinely unable to pay. So while there may be a few outliers of people willfully not paying, people not completing jail time or probation, the overwhelming majority of people are indigent.
I see. Thank you very much.
Thank you.
Thank you. We'd like to thank both counsel for your excellent arguments and for your briefs in this case. At this time, the court is adjourned, and my colleagues and I will retire to deliberate the important issues in this case. Thank you.
Thank you to our judges, and thank you to both participants. At this point, we are going to put the judges into a breakout room. Judges, you should see a notification pop up that is sending you there to deliberate. And while we wait for the judges to get into the breakout room and while they are deliberating, we'll have a brief intermission. Juliana and John, excellent job. You guys can feel free to turn off your cameras while we're doing this. And as soon as the judges go into the breakout rooms to deliberate, I will give a brief bio and introduction of our competitors today.
This is Judge Hendrix. I'm still not receiving the message to go to a breakout room. I'm not sure if it's just me.
No, nor am I.
Okay.
Oh, there it is.
Are you all seeing the notification now?
Not yet. I'm sure it'll be here soon, but not yet.
Okay, just let us know if not. So,
All right. It just popped up. Thank you so much.
okay,
I'm
perfect.
sorry to interrupt.
All right. Okay. Okay, so in just a second, another one of the coordinators will be putting into the chat our program for today, and that will have information about the finalists, information about the judges, and a little bit of background on the problem if anyone's curious as to that. But I'm going to go ahead and briefly introduce the finalists who both did a really excellent job against a really hot bench. So I think finalists, you should be very impressed with yourselves, and everyone should be very impressed with them. So starting with the counsel for the petitioners, we have Julianna Ricigliano. Juliana grew up in New Jersey and graduated from Villanova University in 2020. At Duke, she is a member of If, When, How, Lawyering for Reproductive Justice, and the Coalition Against Gendered Violence. Following graduation, Juliana hopes to do litigation at a firm in New York and clerk. Our counsel for respondents is John Addy. John hails from the greater Culpeper, Virginia metro area. He graduated from the University of Virginia in May 2020, where he studied finance and economics. Here at Duke, John is involved with the Duke Bar Association, the Federalist Society, and the Business Law Society. After graduation, he hopes to clerk before practicing commercial litigation in DC. In his limited free time away from Zoom, he enjoys golf, cards, and college basketball. So those are our competitors. And I think in just a second, we should have the program in the chat.
All rise. The Supreme Court has rendered a decision.
All right, good afternoon again, and welcome back. The panel members, my fellow panel members, Justice Scriven, Justice Hendrix, and I have deliberated.
Justice Blackburn, are we going to have the candidates come back onto video?
Let's see. Thank you, Justice
Thank you.
Scriven. Are the petitioner, counsel for the petitioner, and counsel for the respondent? Yes. Thank you. Welcome back, Ms. Ricigliano and Mr. Addy. And want to again thank both of you for the tremendous job you did with your arguments. We struggled with the deliberations. It was very close. I think my panel members and I, however, have determined that with a slight edge, it's our view that Ms. Ricigliano, counsel for the petitioner, has won the oral argument presentation. Though we say it's a very difficult decision, the two of you did a tremendous job. And what we'd like to do, if we might, is each take just a few brief moments to each offer you our comments and insights. And I will start and be very brief and just say again how difficult the decision was. It was a very interesting, relevant, and difficult case for both sides to argue. Ms. Ricigliano, we thought that your oral advocacy demonstrated an ease and conversational tone that was responsive to our questions, a good command of the record, which was in your favor, the decisions at the district court, more so than the final en banc 11th Circuit case. That you really gave us a roadmap. You returned to it even when our questions took you off task a little bit. You were able to get your footing, respond directly, and then pivot back to your arguments. So I think you had a good rapport with the panel, a good command of the legal arguments and of the facts in the record, and you did an excellent job. Congratulations. Mr. Addy, you did an excellent job as an advocate. I have to say that as the respondent coming second, you gave the bench a chance to warm up a little bit, as we like to say. So you came into a hot bench, as we would call it, and we may have jumped in with our questions to you a little more quickly than we did at the outset with the petitioner. I thought you did an excellent job in responding to the questions. There were a couple times where our questions may have taken you away from your argument, and it took you a few minutes to get back to your main themes, but I think you did a good job of pivoting back to those points. I thought that in your instance, representing the respondent and the government of Florida, Governor of Florida, your strong point was the 11th Circuit en banc decision. And there may have been a few additional points of that circuit decision that you could have hammered on and repeated. But I thought you did a really good job bringing to light the reasons that the government has an interest in the disenfranchisement of people who commit felonies, and then the re-enfranchisement of those felons when they fulfill their commitment to society, and the rehabilitation goal as well as the restitution goal. I think you have a good presence before the bench, very dignified, very thoughtful, and you did an excellent job. And we had difficulty, which explains why we were out deliberating for so long. Justice Scriven?
Good afternoon. I would echo both the comments that my colleague made for both of the candidates. I thought you were both excellent. I heard the introduction, how short a time you all have had to deal with this record. And this law is very complicated. It hails from my fabulous state of Florida. So I appreciate the elucidation that you all have provided. I hope I never have to see any part of this case. I agreed that the edge went to Ms. Ricigliano. I thought that your roadmap at the beginning was clearer. You have learned the lesson early that if you can't rely on the law, lean on the policy, and you were way over on the policy, leaning hard and consistently. And I think that's what you have to do, especially in a con law question, because you're at the Supreme Court where the sausage is made. We get to tell the people what the answer is, and you gave us a chance to do that and the reasons to do that. Record mastery, I'll have to give you props on that at the very, very end when my colleague asked you a question about poverty and how do we know it's not rich people not paying. You pulled the record out and popped him on the head with it, and there was nowhere he could go with it. So I thought that was excellent. You got a little sing-songy at the end. You'll listen, if you listen to the tape, when you get nervous, you kind of start saying like, this is what I'm trying to tell you. And you got to pull away from that in your future arguments. But I think you have a great future in oral advocacy. Mr. Addy, you're a flat-footed, perfect lawyer to do this very mean argument about not letting people vote when they haven't paid their fines, and you were not apologetic. The state has so said, and you're there to support the state's interest. There is an interest in justice, and you were very clear about that. You gave a nod to us trial judges, which I appreciated when I asked you the question about what about the millionaire fraudster and the poor guy with $500. You said, well, the trial judge gave that judgment. That's the judgment. We're not here to rethink that. You have a good cadence, which you should maintain. The only thing that kind of threw you off is my question about who's to pay the fines. And when somebody asks you a question like that, your answer is that's not an issue to be decided here today. Florida will decide who's to pay the fines and who's not. And I think you kind of took a tangent and took a bait, and it took you off course. But I thought overall, both of you did an excellent job, and I commend you for this work.
All right, I agree with everything that has been said. First of all, let me just say, you're both 1Ls, is that right? I mean, that's unbelievable that you have done this well in a difficult oral argument and a tough problem for both sides, really. And you both just did fantastic. So really, you should both be so incredibly proud of yourselves. To be the finalists at such a fantastic law school is quite the accomplishment. Look, I have argued a lot of appellate cases. That's primarily what I did before I took the bench. And I know how hard this is, so please trust me when I know. And that you did as well as you both did as first years is really phenomenal. So I want to give you some feedback, but please know that, again, this was a very, very difficult decision, and you've both just done so well, especially given that your first years. The first thing I would just tell both of you is this job, this role requires you to practice instant forgiveness of yourself in the middle of an argument. Both of you, I think, got hung up on a few things, and it doesn't come out exactly like you come out, and you just have to let it go immediately. And that is difficult to do. There'll be plenty of time to beat yourself up afterwards, I guarantee it. But these judges, we know you're human. None of us can speak clearly for 10 minutes when we're being peppered with questions without having a problem. So we understand that. And as long as you are just candid and respectful, you're going to be forgiven by us and pivot where you need to pivot and just move on. Mr. Addy, let me start specifically with you. I mean, you knew the cases so well. You really knew your weaknesses and were ready to give up what you had to give up. And that is a difficult thing to do. I started taking you down a line of hypotheticals, and, the first two were just no brainers. Look, can the state allow, I think I said white felons to vote, but not black felons, or male felons, but not female felons. When clearly a judge, so one, you gave it up and you said, no, that wouldn't be okay. That's the right answer. Good job. Clearly I'm building to a point, right? When that's happening, that is, I think, one of the few times where you just answer and let the judge keep cooking, right? Don't try to pivot from there, because clearly I'm building to a point, and try to anticipate what's coming. And I was leading to a point, and you did your best with the tough question that I gave you, but it was good of you to be able to give up what you could. You were candid in that regard, and I appreciated that. The thing that but all oral advocates have to work on is just answering the questions directly. And that can be really difficult when the questions are rough. Judge Scrivener, right out of the gate, asked you about, look, what's rational about not allowing poor people who can't pay a fine to vote, but allowing rich people who can? What's rational about that? And it took a while for you to really get to the answer. And that's the core of your case. I mean, you've got to have that in the can, ready to go, anticipate that weakness, and just have it ready. But you're going to have to get down in the weeds of your weakness. And that's what the best advocates do. And when she asks you that tough question, that's gold, because she's revealing to you her biggest problem, right? And at least you get a chance to answer it, before she goes back and you don't have a voice anymore. So don't be afraid of those moments, embrace those moments. I'll also say you were just steady. You came out of like central casting for government lawyer. You have some tough facts here, but you seem totally unflappable. Like Justice Scrivener said, unapologetic. This is okay. This is the people's choice, and they chose. And rational basis. Come on, this is an incredibly deferential standard. I would hit that a little bit more if I were you on the substance, the rational basis. But overall, seriously, great job. Tough and a tough draw. Ms. Ricigliano, you were passionate, but appropriately so. I mean, clearly we're in the Supreme Court, so this is an oral argument. This is not a jury argument, but you really showed that you believed in your case. And look, if we as judges don't think the lawyer believes in the case, it's hard for us to believe in your case. And you really showed that, and you did that really well. You were respectful. I started about halfway through, I started getting, some hot questions at you, and you stopped. As soon as I opened my mouth, you stopped talking. And that is the right thing to do. And it's harder when you're passionate about your case, but man, you just knocked it out of the park on that. So really good job. Both of you had great eye contact. As Justice Scrivener said, you knew the record cold and you shut me down with it. That was great. My comments on the other side of the ledger are similar to what I told Mr. Addy. You've got to figure out what you must give up and what you can give up without giving up your case. I asked you, for example, look, has any court ever applied heightened scrutiny under these kinds of circumstances involving felon reenfranchisement? And I think the answer is no, but that's okay. We're at the Supreme Court now. We can do that, right? But is it uncomfortable for you to say this has never happened before? Yeah, it'd be great if you had some examples that you could point to us. But if you had examples, it probably wouldn't be at the Supreme Court. So just own that up front. No one's ever done this, and that is what I'm asking you to do, but there's 3 good reasons why. First, right? No big deal. Just move on. Also similar on rational basis review. One of the justices asked you, look, if this is rational basis, do you lose? That's essentially what we asked. And you had the exact same level of confidence, and I like the passion, but I'm not sure that's accurate. I think you need to own that's a much tougher row for us to hoe, but we're ready to do it and we can do it. Just a recognition, because if it's always, nope, it's all good, everything's perfect, I'm fine, the credibility decreases a little bit. And I didn't think you were trying to pull a fast one on us, but own your weaknesses and you'll be even better. But I mean, these points for both of you are just how to go from good to great. You both just did a great job. So you should be proud of yourselves, and congratulations.
Well, thank you again to our esteemed counsel, Ms. Ricigliano and Mr. Addy. Well done. As a Duke undergrad alum, I'm very proud of what I see from you all, what we all saw today. To you too, and to all of the students who participated in the earlier rounds of this moot court competition. This is important, and it helps prepare you and continue to prepare you to be excellent advocates for your clients and for important societal issues like this. So keep up the good work. I'm sure you realized how hard it was, especially given the short time frame. And it's really hard to make it look easy the way that you did. And we appreciate that. At this point, I'm not sure exactly what happens. Is someone going to take us to another breakout group? Or does that I believe we had a virtual reception and an opportunity to talk further with students. Could someone let us know what our next steps are from here, please?
Yes, so in just a moment, we'll be starting the reception and doing breakout rooms again. But before we conclude, on behalf of the Hardt Cup coordinators and the Moot Court Board, I would just like to take the time to congratulate our 2021 Hardt Cup champion, Julianna Ricigliano. We also extend congratulations to both finalists for a truly excellent and impressive final round. As a 2L who's watched these before, I say honestly, this was really impressive and fun to watch. And we'd also like to extend congratulations to all of our new Moot Court Board members and to every participant in this year's Hardt Cup. We'd also like to thank everyone who was involved in putting on this tournament. First and foremost, thank you again to Chief Judge Blackburne-Rigsby, Judge Scriven, and Judge Hendrix for being here and making this round incredibly fun and dynamic to watch. Thank you to every one of you who showed up to watch, and to all the Moot Court Board members, faculty, and practitioners who judged earlier rounds. And finally, on behalf of the Hardt Cup coordinator, I want to extend a huge thank you to Zach Kaplan and Madison Whalen for all of their help every step of the way. So thank you again to everybody, and we hope that you have a great weekend.
May I say one last quick thing? Each of the three of us members of the panel have expressed an interest. My current law clerk is a Duke Law alum. I believe Justice Scriven has indicated her current law clerk is a Duke Law alum, and Justice Hendrix has expressed interest in applicants who might be interested in clerking for him. And so I also have internships available in your 2L and 3L years. So consider that as you all are progressing in your law studies and preparing the early stages of your legal career.
So is there a room we'll go to for the reception, or do we stay here, or do we go to little individual breakout rooms?
Yeah, we will send everyone to breakout rooms. We'll just wait a minute for all the audience members to kind of clear out so we can figure out who's in the room, where to go, everything.